Chapter 31, Equitable Relief Against Actions, Judgments and Executions at Law. Analysis. Section 637. Origin of the Jurisdiction. The use of injunctions to stay actions at law was almost coeval with the establishment of the Chancery jurisdiction. Without this means of interference to protect the rights of its suitors, the Court of Chancery could never have established, extended, and enforced its own jurisdiction. It is no exaggeratio to say that, during its formative periods, the equitable jurisdiction was built up through the instrumentality of the injunction restraining the prosecution of legal actions, where the defendants sought the aid of Chancery, which alone could take cognizance of the equities that would defeat a recovery at law against them. This was not accomplished, however, without a long and severe opposition from the common law judges, which continued until the reign of James I. The jurisdiction then firmly established by judicial authority has never since been questioned. The reasons urged by the common law judges were frivolous. The injunction is not addressed to, nor does it operate upon, the courts of law. Instead of denying or interfering with, it virtually admits and assumes their jurisdiction. It is addressed to the litigant parties, and prohibits them from resorting to the legal jurisdiction, because their controversies, depending upon equitable principles, or involving equitable features, can only be fully and finally determined by a tribunal having the equitable jurisdiction. Injunction is the remedy which, above all others, necessarily operates in personam. Section 638. When the jurisdiction is not exercised, general doctrine, where a court of law can do as full justice to the parties and to the matter in dispute as can be done in equity, a court of equity will not stay proceedings at law. Equity will not restrain a legal action or judgment where the controversy would be decided by the court of equity upon a ground equally available at law, unless the party invoking the aid of equity can show some special equitable feature or ground of relief, and in the case assumed, this special feature or ground must necessarily be something connected with the mode of trying and deciding the legal action, and not with the cause of action or the defense themselves. It is not such a special equitable ground of interference that the party has, by his own act or omission, failed to effectually avail himself of a valid defense at law, nor that the court of law has decided a question of law or of fact erroneously. The principle is well established, and is universal in its application, that when a cause belongs to the jurisdiction of the law courts, equity will never interfere to restrain the prosecution of the action, nor to stay proceedings on the judgment or execution, upon any mere legal grounds, although it may be demonstrated that the complainant in equity, generally the defendant at law, had a valid legal defense, which was not made available either through the error of the court in determining the law or the facts, or the omissions of himself or his counsel in presenting it, or in obtaining the evidence by which it could have been supported. Section 639. Same inexcusable neglect. Equity will not relieve one whose inexcusable neglect in the defense or prosecution of an action has resulted in a judgment against him. What amounts to such neglect depends largely upon the circumstances of each particular case. Where a party negligently fails to have an appearance properly made, and a default results, a court of equity will generally deny relief, and a like result may be reached when the judgment results from a negligent failure to attend the trial. A neglect to set up a known legal defense will bar equitable relief growing out of it. Ignorance of facts constituting a defense does not excuse the omission of a party to make it, nor entitle him to the aid of equity, unless it can be shown that the party could not have acquired the information by the diligent and careful labor in preparing the cause for trial which he is bound to make. Where a right of appeal has been lost by negligence, equity will not ordinarily interfere. It is generally held in all of these matters that the neglect of an attorney is imputable to his client. Of course, where it appears that the neglect has been caused by the promises or statements of the adverse party, or where, for any reason, it is excusable, relief may be freely granted. Section 640. Jurisdiction of federal courts to enjoin proceedings in state courts. Congress has provided that the writ of injunction shall not be granted by any court of the United States to stay proceedings in any court of a state, except in cases where such injunction may be authorized by any law relating to proceedings in bankruptcy. This provision has limited the powers of the federal courts, and in most cases prevents the exercise of the jurisdiction. Injunctions in aid of bankruptcy proceedings being expressly accepted by the statute, such relief is quite frequently given. The statute does not apply when the jurisdiction of a federal court has first attached. Accordingly, a federal court may grant an injunction against a proceeding in a state court when necessary to render effective its own decree. It is also held that injunctions may issue in cases which have been regularly removed from state courts, to restrain further proceedings. Section 641. State courts cannot enjoin proceedings of federal courts. It is well established that a state court cannot enjoin a proceeding or judgment of a federal court. The jurisdictions are independent, and there is no right in a state court to interfere. The exemption of the authority of the courts of the United States from interference by legislative or judicial action of the states is essential to their independence and efficiency. Section 642, Relief from equitable proceedings and decrees. As a general rule, one court of equity will not enjoin the process of another of co-ordinate jurisdiction. Relief is obtainable by application to the court which has jurisdiction of the original suit. Occasionally, however, one court of equity will interfere with the proceedings of another, as where it is necessary to prevent a multiplicity of suits. Likewise, a court which has jurisdiction of an equitable action may enjoin the prosecution of another concerning the same subject matter, subsequently begun in another court. An injunction may be granted against prosecuting a suit in or enforcing a decree of the same court, and upon the principle of quia timit, an injunction may issue to restrain the prosecution of a suit not commenced, such as a suit to foreclose a mortgage. Section 643, Probate decrees. It is said by some courts that equity has no jurisdiction to enjoin or set aside probate decrees obtained by fraud, except in jurisdictions where perjury is a ground for relief against judgments. Cases in which equitable relief would be proper under the general principles are comparatively rare. A probate proceeding is generally ex parte. Cases do occur, however, in which a party is prevented, by some fraud or mistake, from having a hearing to which he is entitled, and under such circumstances, it would seem that equity should take jurisdiction. Section 644. No injunction against criminal proceedings. In general, a court of equity has no jurisdiction to enjoin criminal proceedings. To assume such a jurisdiction, or to sustain a bill in equity to restrain or relieve against proceedings for the punishment of offences, is to invade the domain of the courts of common law, or of the executive and administrative departments of the government. Moreover, in the United States it is held that such a suit is in effect against a state, and is therefore prohibited by the federal constitution. While the general rule is well established, it has been intimated that when prosecutions are threatened under color of an invalid statute for the purpose of compelling the relinquishment of a property right, the remedy in chancery is available. There are also many cases in which the enforcement of void municipal ordinances, the execution of which directly affected property rights, have been enjoined, and criminal prosecutions before the municipal authorities restrained. Section 645. When the jurisdiction may be exercised, first class, equitable rights. I pass from this negative view to consider the doctrine on its affirmative side. The cases in which, according to its original jurisdiction unaffected by statute, equity may interfere by injunction, and restrain an action at law either before or after judgment, may be reduced to three general classes. 1. Where the controversy, in addition to its legal aspect, involves some equitable estate, right, or interest which is exclusively cognizable by a court of equity, so that a complete determination of the issues cannot be made by a court of law. It is well settled that equity not only may, but must, interfere at the suit of the party in whom the equitable estate or right is vested, and restrain the action at law, and decide the whole controversy. This is so when the defendant at law has a purely equitable defense which the court of law will not recognize or enforce, and especially when he is entitled to some affirmative equitable relief which will clothe him with a legal right or title, and thus defeat the legal action brought against him. Cases of this kind belong to the first branch of the exclusive jurisdiction of equity as described in the first volume. This rule assumes that the equitable questions contained in the defense extend to the entire cause, so that their decision determines the controversy. When the cause contains both legal and equitable questions which are distinct, the Court of Equity, while taking jurisdiction, may not restrain the proceedings at law prior to the obtaining of judgment. Section 646. Same, second class. The second general class includes those cases which belong to the second branch of the exclusive jurisdiction of equity as heretofore described, or, in the ordinary nomenclature of the books, cases over the facts of which both courts of law and of equity have a concurrent jurisdiction to grant their respective and distinctive remedies. For example, cases involving actual fraud, such as suits upon instruments, where the defense is fraud in procuring their execution, where the jurisdiction is thus said to be concurrent, or in other words, where the interests and primary rights of the parties are legal, and the only question between the two courts relates to the adequacy of their respective remedies. As a general rule, the tribunal which first exercises jurisdiction is entitled, or at least permitted, to retain an exclusive control of the issues. It is therefore a well-settled doctrine that in cases of this kind, where the primary rights of both parties are legal, and courts of law will grant their remedies, and courts of equity may also grant their peculiar remedies, equity will not interfere to restrain the action or judgment at law, provided the legal remedy will be adequate, that is, provided the judgment at law will do full justice between the parties, and will afford a complete relief. The adequacy or inadequacy of the legal remedy is the sole and universal test. On the other hand, in cases of this general class, equity will enjoin the action at law, and will determine the whole cause, whenever the legal remedy is inadequate, and the legal remedy is deemed to be inadequate if the ends of justice would not be satisfied by a mere judgment for the defendant in the action at law, but would require that some distinctively equitable relief, such as a cancellation or a reformation of the instrument sued upon, be conferred upon him. If any affirmative equitable relief is necessary to a full settlement of the controversy, and to a complete protection of the defendant's rights, a court of equity will interfere, entertain a suit for such relief, and enjoin the action at law. The scope of this particular doctrine is plainly identical with that which governs the second branch of the exclusive jurisdiction of equity as described in the first volume. Whenever a court of equity exercises its jurisdiction over a case involving only legal interests and primary rights, for the purpose of awarding its exclusively equitable remedies, because the legal remedies would be inadequate, it will always, if necessary, enjoin an action at law which interrupts the full exercise of its jurisdiction. Section 647. Same third class. In the two preceding classes of cases, the ground for interference was some equitable element or feature involved in the very subject matter of the controversy, or in the remedies appropriate thereto, which constituted an equitable defense in full or in part to the legal action, and over which the Court of Equity had either a concurrent or an exclusive jurisdiction. In the present class there is no such equitable element or feature of the controversy, there is no equitable defense embraced in any possible issues, no equitable right or interest of the defendant which defeats or modifies the legal cause of action. All the issues are wholly legal. The ground for the equitable jurisdiction to interfere is, therefore, something dehors the issues, something arising out of or connected with the trial itself of the legal action in the court of law. It was a settled doctrine of the equitable jurisdiction and is still a subsisting doctrine except where it has been modified or abrogated by statute, or has become obsolete through the enlarged powers of the law courts to grant new trials, that where the legal judgment was obtained or entered through fraud, mistake, or accident, or where the defendant in the action, having a valid legal defense on the merits, was prevented in any manner from maintaining it by fraud, mistake, or accident, and there had been no negligence, laches, or other fault on his part, or on the part of his agents, then a court of equity will interfere at his suit, and restrain proceedings on the judgment which cannot be conscientiously enforced. From the very nature of the case, this interference takes place after the judgment, and not while the action at law is pending. Section 648. Rationale of the doctrine. The ground for the exercise of this jurisdiction is that there has been no fair adversary trial at law. Consequently a distinction is made between fraud, accident, mistake and the like relating to the subject matter of the action and similar elements relating to the conduct of the suit. Fraud relating to the subject matter is not of itself sufficient ground for relief, where it relates to the conduct of the suit, as where it prevents a party from asserting his rights. There is no fair adversary proceeding, and equity will interfere. The courts commonly speak of the former class as intrinsic and of the latter as extrinsic, fraud, etc. Thus, it is generally said that it is extrinsic fraud, mistake and the like which are grounds for relief. Section 649. Fraud as a ground for relief. Where the unsuccessful party has been prevented from exhibiting fully his case, by fraud or deception practiced on him by his opponent, as by keeping him away from court, or by a false offer of a compromise, or where the defendant never had knowledge of the suit, being kept in ignorance by the acts of the plaintiff, or where an attorney fraudulently or without authority assumes to represent a party and connives at his defeat, or where the attorney regularly employed corruptly sells out his client's interests to the other side. These, and similar cases which show that there has never been a real contest in the trial or hearing of the case, are reasons for which a new suit may be sustained to set aside and annul the former judgment or decree, and open the case for a new trial and a fair hearing. It will be seen that the fraud here is not necessarily actual, legal fraud. Section 650. Violation of stipulation or agreement. Relief is very freely granted where a judgment is taken in violation of a stipulation or agreement as to the conduct of the suit. It is apparent that there is no fraud in the technical sense. Such conduct does not fall within the definition of actual fraud, misrepresentation of existing facts. There is merely a breach of a contract, but the effects of such a breach are so manifestly against conscience that the courts will relieve, and base their jurisdiction on the ground of fraud. These stipulations may take various forms. Where an attorney represents that a case will not be called at a certain term of court, equity will enjoin or set aside a judgment entered at that term in the absence of the complainant. Likewise, where there is an agreement that a case is not to be tried without notice, relief will be granted against a judgment entered without notice. A party may rely upon a statement that an action will be dismissed, and if his opponent, in violation of such an agreement, takes judgment, equitable relief is proper. Where a party induces another to allow judgment to be taken against him upon the representation that it is not to be enforced against him, or that if the amount shall turn out to be too large, it will be corrected, an injunction will issue to prevent the enforcement of the judgment in violation of the agreement. Equity will also relieve against a judgment obtained in violation of a compromise agreement. An inferior court has enjoined the enforcement of an order made by a higher court, surreptitiously and fraudulently obtained. Thus, where a judgment obtained by consent was reversed in the appellate court because the consent did not appear of record, the lower court granted relief, and its decision was sustained on appeal. In general, whenever a party has been lulled into inaction by the promises, stipulations or representations of the prevailing party, relief will be granted because of the unconscionable conduct. If, however, the promises, stipulations or representations are such that the defendant at law was not justified in relying upon them, relief will be denied. Section 651. Miscellaneous instances of unconscionable conduct. The unconscionable conduct may assume many forms. If an attorney employed to defend a case proves false to his trust and, in conjunction with his opponent, allows judgment to go against his client, a clear case for equitable relief is made out. Likewise, if a director of a corporation defendant, or any other person occupying a fiduciary position, fraudulently allows judgment to be taken without attempting to have a defense made, equity will relieve. Collusion is a well-established ground. In such cases the bill for relief is generally brought by a third party who is injured by the collusive conduct of the parties to the original action. The rule seems to be that whenever the existence of a judgment, or the uses of which it is capable, and which are imminent, injuriously affect the rights or remedies of a stranger to it, he may by original bill attack it for fraud or collusion. Such, for instance, may be creditors' bills, and bills by legatees against, is-a-bill executors and administrators. Such, also, brought by citizens to set aside a writ of mandate to compel a canvass of votes, obtained by collusion between the relator and the defendant. Of course, where collusion is between a trustee and a claimant, The cestui is entitled to relief, one who prevents his opponent from answering by fraudulently waiting until he goes out of the jurisdiction before bringing suit, or by wrongfully having him confined in an asylum, or by inducing him to leave the country, is guilty of such unconscionable conduct that equity will readily interfere. Where the prevailing party tampers with the jury, an injunction may issue if the facts are discovered at so late a time that legal relief cannot be secured. If the judge himself is a party to the fraud, the ground for interference is especially strong, and in such a case it need not be shown that he intentionally did wrong. It is ground for relief when a party attempts to take advantage of an error of the clerk in failing to properly enter an order of the court. Section 652. Same continued. Where it has appeared that a probate court has awarded the whole estate of an intestate to a brother, omitting entirely the widow, who understood little of the English language, relief has been granted. These facts were held sufficient to show that the court either labored under a mistake or was fraudulently imposed upon. Again, where the defendant has not appeared and a personal judgment has been taken, although unauthorized by the petition, an injunction has issued. Where money is fraudulently coerced by a judgment fraudulently obtained, it is sometimes held that it may be recovered in equity, without the formality of obtaining a new trial or setting aside the judgment. Where an order or decree in a probate matter is obtained by fraud, relief may sometimes be granted. Many cases upholding the general doctrine in its various phases are appended in the note. Go. Section 653. Fraud subsequent to trial. Relief may be granted to a party injured by the fraudulent conduct of his opponent after the trial. Thus, where too large an amount is fraudulently entered in a decree by counsel, or where one decree is fraudulently substituted for another, equity may interfere, but the mere fact that an attorney, requested by a judge to frame a decree, acts fraudulently, is no ground for relief unless it is affirmatively shown that the judge has been imposed upon. It will be presumed that the judge has done his duty. An injunction may issue to restrain a party from keeping a judgment alive after it has been satisfied. Not only may the defendant at law obtain equitable relief, but the plaintiff as well may in a proper case invoke its aid. Thus, where a plaintiff releases one of two joint debtors upon the urgent request of the other, and upon a promise by such other to pay, an injunction will issue to restrain such a party from taking advantage of his right at law to cancel the judgment. Section 654. Fraudulent concealment. Fraudulent concealment is sometimes relied upon as a ground for equitable relief against judgments. In order that concealment shall be ground for any equitable relief, there must be a duty to disclose. Ordinarily, when there are two parties on an equal footing before the court, there is no such duty. The concealment which is ground for relief generally arises in an ex parte proceeding where the court is deceived by facts concealed by the applicant for relief. Where fraudulent concealment is relied upon for the purpose of impeaching and setting aside a judgment regularly obtained, it must be an intentional concealment of material or controlling fact, for the purpose of misleading or taking an undue advantage of the opposite party. That the adversary has not communicated facts which tend to defeat his claim or to impeach his witnesses is not ground for relief. An adversary cannot be expected to furnish the means for his defeat. Section 655. Instances of refusal of relief. Relief in equity will be refused where it appears that the fraud, even if attempted, was not successful. The mere fact that there is prejudice in the community which may prevent a fair trial is not ground for relief, for there is an adequate remedy at law, nor does the fact that complainant was not notified of a default judgment show any unconscionable conduct. The mere filing of a brief, surreptitiously perhaps, cannot be taken advantage of, for the court is not supposed to decide the case upon the briefs. Other cases where it was held that no fraud was shown are appended in the note. Section 656. Perjury. The courts hold that perjury is intrinsic fraud and that therefore it is not ground for equitable relief against a judgment resulting from it. We have seen that the fraud which warrants equity in interfering with such a solemn thing as a judgment must be fraud in obtaining the judgment, and must be such as prevents the losing party from having an adversary trial of the issue. Perjury is a fraud in obtaining the judgment, but it does not prevent an adversary trial. The losing party is before the court and is well able to make his defense. His opponent does nothing to prevent it. This rule seems harsh, for often a party will lose valuable rights because of the perjury of his adversary. However, public policy seems to demand that there be an end to litigation. If perjury were accepted as a ground for relief, litigation might be endless. The same issues would have to be tried repeatedly. As stated in a leading case, the wrong, in such case, is of course a most grievous one, and no doubt the legislature and the courts would be glad to redress it if a rule could be devised that would remedy the evil without producing mischiefs far worse than the evil to be remedied. Endless litigation, in which nothing was ever finally determined, would be worse than occasional miscarriages of justice, and so the rule is, that a final judgment cannot be annulled merely because it can be shown to have been based on perjured testimony, for if this could be done once, it could be done again and again ad infinitum. And to use the language of an eminent court, the maxim that fraud vitiates every proceeding must be taken, like other general maxims, to apply to cases where proof of fraud is admissible. But where the same matter has been actually tried, or so in issue that it might have been tried, it is not again admissible. The party is estopped to set up such fraud, because the judgment is the highest evidence and cannot be contradicted. In accordance with the principles laid down above, it is held, by the weight of authority, that neither perjury nor forgery is sufficient ground for equitable interference. There is quite respectable authority, however, the other way, and many are disposed to regard this minority rule as more in accordance with justice. In Nebraska the cases cited lay down the rule that the intentional production by a litigant of false testimony to establish his cause of action or defense amounts to such a fraud as will, in a proper case, entitle the adverse party, if unsuccessful, to the vacation of the judgment rendered against him. In a late case, however, it is said that actions of this kind are not to be encouraged, for public policy demands that there shall be an end to litigation. In some jurisdictions it is laid down that evidence of perjury is not sufficient ground for relief unless it appears to a reasonable certainty that, but for such testimony, the judgment would have been different. In one case a distinction is attempted between actions at law and suits in equity, the contention being that perjury in an equity case is ground for relief. In Washington and Oregon the general rule is guarded with limitations which appear to mitigate its harshness without contravening its policy. It would seem correct to hold that while perjury itself may not be ground for relief, it may be considered along with other circumstances to show a fraudulent intent. It would appear that a distinction might properly be drawn between cases in which two parties are before the court and ex parte proceedings. In the latter there is no adversary trial, so on principle there is no reason why relief should not be granted. Such was the holding in at least one state, California, but later decisions in that state have now greatly narrowed the exception as to ex parte proceedings. It is held that where there is a fraudulent concealment in connection with the perjury, equitable relief will be granted. It is difficult to imagine any ground upon which such a distinction can be upheld. Whether there is active perjury or passive concealment, there is still a fraud upon the court. To the average mind it will seem that an active falsehood is stronger ground for relief than passive concealment. Section 657. Accident, mistake and surprise. In general, relief is frequently granted where, on account of accident, mistake or surprise, a party has, without his fault, been deprived of or caused not to present some cause of action or matter of defense. The complaining party must not be at fault. Section 658. Accident. The accident which is ground for relief in equity against a judgment must consist in circumstances beyond the control of the complaining party, which prevent him from obtaining proper relief, as in the case of fraud. The accident must relate to extrinsic matters, rather than to intrinsic. A most common illustration is where a party, without lackey on his part, loses the benefit of a bill of exceptions by the death or illness of a judge, so that it cannot be signed and sealed. In such a case equity will interfere and grant proper relief. Likewise it has been held that where a statement of a case upon appeal has been lost without fault of the attorneys for the appellant, and, by reason of lapse of time, the judge is unable to settle the bill of exceptions, equity will relieve. Again, where a judge of a trial court is disabled by sudden sickness from disposing of a motion for a new trial during the term at which the judgment was rendered, the party filing the motion may, upon showing the facts in his complaint, and that he was guilty of no negligence, and had a meritorious defense or cause of action, obtain relief in equity. Relief has also been allowed where an attorney who was entrusted with the duty of making a defense was prevented from reaching court by ice in a river which he had to cross to reach the courthouse. Sickness of a party may be a valid excuse for not appearing. Such cases, however, must depend upon the peculiar facts of each particular case. If a party has an attorney who can adequately present his defense, and if the presence of the party in court is not essential, sickness is not sufficient ground for relief. If, on the other hand, the party is needed as a witness, or if he is so sick when served that he cannot even take the first step of hiring an attorney, equity will relieve. The accident may consist in the failure of a state officer to perform a statutory duty, or to follow established rules, thus depriving a party of an opportunity to make a defense. Section 659. Mistake. It is a familiar doctrine that a mistake of law will not be relieved against save in certain exceptional cases. This principle is generally applied to relief against judgments. Bearing in mind that we are now considering only mistakes as to the proceedings, it is clear that a party should not be allowed to set up his lack of knowledge of law as a reason for not presenting his case. If he were allowed this right, it would be a very simple matter for an unsuccessful litigant to obtain a new trial on the ground that he did not present certain evidence because he thought it would not be admissible. The advice of counsel that there is no diffuse, or a similar expression from the judge on the bench, will not be sufficient to warrant equity in relieving from a mistaken course taken in reliance on such advice. Mistakes of fact in this connection may be divided into two classes: mistakes by a party or his attorney, and mistakes by some officer of the court. These classes cannot be sharply distinguished, for it often happens that the mistake of the court is due to a mistake of a party. In order that a mistake of a party may be ground for relief, there must be no neglect on his part. A mistake due to one's own failure to investigate is not such as will warrant relief. But where there is no negligence, and a party is prevented from presenting his case properly on account of a mistake of fact, equity will interfere and will relieve. Thus, where an attorney for a plaintiff makes an error in the calculation of interest and takes a judgment for too small an amount, relief may be granted, for the error is merely clerical. Likewise, where the amount of attorney's fees was agreed to in court under a mistake of fact as to the value of the estate, or where a widow makes an election to take under a will under a similar mistake, equity will relieve. Section 660. Same mistake of officers of court. When the court, or some officer thereof, makes a mistake of fact, not judicial in its nature, equity may relieve. Of course, if the mistake is judicial, there is an adequate remedy by appeal. It often happens that owing to a mistake of fact there is an error in the judgment, or that it describes land, or that a judgment is given not warranted by the pleadings. In such cases relief may be awarded. Thus, where a decree of distribution omits a legatee, or where a record of a deed is inaccurate so that judgment has gone against a party, the jurisdiction is clear. The mistake may be made by the jury in calculating the amount due. Where a judgment is entered on an agreement to which one defendant's name was forged, although a co-defendant who forged it was the only culpable party, relief will be granted, for the judgment is entered under a mistake of fact. In order to warrant relief, there must be clear and conclusive evidence of mistake. Section 661. Same newly discovered evidence. It frequently happens that a party, through no fault of his own, is ignorant of facts constituting a defense to the action. The rule in such cases is that equity will relieve if the party could not, by the exercise of reasonable diligence, have obtained the evidence. But if there has been an ample opportunity to discover the evidence, and it is not then forthcoming, relief will be denied. Section 662. Surprise. Surprise is also frequently stated to be ground for equitable relief, as in the case of all the other matters which constitute grounds for relief against judgments. There must be no negligence. The surprise which is ground for relief must consist in something in the proceedings which the party did not expect and which he had no reasonable ground to expect. The doctrine will be best illustrated by examining the facts of a few cases. Thus, in a federal case, foreigners were sued and were represented by an attorney. At the trial the complaint was amended, and the attorney was unable to meet the amendments. It was held a proper case for equitable interference. Again, In another case, a verdict was obtained against the plaintiff by the production of a receipt signed by his agent, of which he was not notified and probably had no knowledge, and which he had no reason to expect would be produced. It was shown by evidence obtained too late to be available at law that the receipt was in reality given for other money. This was held to be ground for relief. An injunction has issued against the enforcement of a judgment of a justice of the peace who agreed to notify the complainant of the time set for trial, but failed to do so. The mere failure of an attorney, who has been employed, to appear does not constitute surprise, especially when the party has not supplied him with the facts necessary for a defense. Ordinarily, when unexpected testimony is introduced, it is the duty of the surprised party to ask for a continuance, and it would seem, in the absence of such a motion, that equitable relief should be denied. Section 663. Want of jurisdiction, failure to serve summons or process. In many cases courts of equity will interfere to prevent injustice when a court of law has acted without jurisdiction. This interference is based on the inequitable results which follow, and frequently is wholly independent of any wrong on the part of the prevailing party. One of the commonest illustrations is found in cases where no jurisdiction has been obtained because there has been no service of summons or process. The rule seems to be that where the failure to serve a party results in his inability to answer, relief will be granted. On the point as to whether a meritorious defense must be shown, the courts are divided. The question is discussed more at length in a subsequent paragraph. The defect in service may not be apparent on the record, or again, the record itself may show the want of jurisdiction. In the former case, the question arises as to whether a return can be attacked. It was formerly held by common law courts that their judgments purported absolute verity. If the jurisdiction of the court depended upon the false return of an officer to the service of process, the party injured could maintain an action against the officer, but he could not be relieved from the judgment. The modern equity cases have greatly ameliorated this harsh doctrine, and it can be safely stated that the general rule, by the weight of authority, is that a return may be attacked in an action to set aside the judgment. The justice of this rule requires no argument. The remedy at law against an officer is at best of a very doubtful character, and in many cases damages, if recovered, are a wholly inadequate remedy. For example, where the action is for the recovery of land. Some courts, however, have laid down the rule that an officer's return cannot be attacked unless it is willfully false and has been procured by the plaintiff at law. The effect of this is to make the basis of the equity action fraud by the plaintiff at law. The injured party must, if no fraud be shown, depend upon his remedy against the officer. It is everywhere held, however, that the officer's return is prima facie evidence of regularity. The court in a default judgment must find that there has been due service. This finding will be presumed to be correct. Therefore, in order to impeach it, clear and satisfactory evidence must be produced. Often a summons is served by a private individual. In such cases the grounds upon which the officer's return is protected in some jurisdictions do not exist, and accordingly it is believed that an attack on the judgment will generally be allowed. Section 664. Same continued. Where the judgment is attacked because of failure to serve process, the usual principle applies, that relief will not be granted where there is an adequate remedy at law. In most cases, as will be seen upon an examination of those heretofore cited, it is held that there is no such adequate remedy. In some states, however, it is held that a remedy by motion is sufficient and will bar all claim to equitable relief. Much will depend upon the form of the statutes in the various jurisdictions. Where a return is defective on its face, the judgment is clearly void. Some courts divide the cases into two classes: void judgments and voidable judgments, the former being those in which the defect is apparent and the latter those in which it is not. The general rule seems to be that equity will interfere with a judgment even where it is void on its face, provided the legal remedy has been lost. This rule is not universal, however, for some courts, on the analogy of the familiar rule concerning cloud on title, hold that such a judgment, being a nullity, can confer no rights, and that therefore there is always an adequate remedy at law. A mere defect in the service of summons is not sufficient to warrant the interference of equity if the summons gives notice to the defendant so that he can prepare his defense. Where, however, the defect is such that it deprives the defendant of notice, relief will be granted. Thus, equity has interfered where a statute requiring a copy of the declaration to be left at the dwelling house of the defendant if he be absent, the copy is left upon the premises over 100 feet from the house. Likewise, relief is proper when a summons is left at the residence of a defendant who is confined in an insane asylum, and neither he nor anyone for him has notice of the suit. Where, in an action against a corporation, service of process was accepted by the President and the Secretary while acting as agents for the plaintiff, equitable relief was granted. A summons in an action against a corporation must be served upon the proper officer. Accordingly, a judgment rendered on default when service had been made upon a local agent of an insurance company, who had no authority for that purpose, was cancelled. Where service is obtained by publication, by means of a false affidavit, relief may sometimes be granted, but where the acts of the defendant have induced the belief that he is a non-resident, relief will be refused. Section 665. Same, unauthorized appearance of attorney. Closely akin to judgments obtained by default are judgments obtained on the unauthorized appearance of an attorney. An attorney of a court of record is an officer of the court, and when he appears in a case it is presumed that he acts with authority. The earlier cases, following somewhat the same line of argument as that used by the courts which hold that an officer's return cannot be attacked, held that ordinarily the judgment could not be questioned because of the unauthorized appearance of an attorney, unless there was collusion. The remedy was against the attorney only. If he were insolvent, the remedy against him might be inadequate, and in such event equity would probably take jurisdiction. The modern view, however, is that equity will relieve against a judgment obtained without service of process and upon the unauthorized appearance of an attorney. As in the case of the sheriff described in the 2 Proceedings sections, the remedy against an attorney is generally unsatisfactory. Hence it is now held to be immaterial whether the attorney is solvent or not. A party is entitled to his day in court, and if he is deprived of that, whether by collusion or by the wrongful act of the attorney alone, he should be relieved. The constitutions of the various states provide that no person shall be deprived of property without due process of law. To take one's property without giving him an opportunity to be heard is a violation of this provision. Hence it would seem that the duty of a court of equity is clear. An attorney, however, is presumed to act with authority, and therefore the burden of showing the lack is upon the complainant attacking the judgment. Section 666. Same miscellaneous. Numerous other cases may arise in which the court may be without jurisdiction. The amount involved may be too large for the court to take jurisdiction of the suit, and again it may be too small. The judge may be disqualified from acting because of interest in the result. The judgment may be entered before the time to answer has expired. The nature of the suit may be such that the court has no jurisdiction. For instance, in many states a justice's court has no equity jurisdiction, and if it assumes such jurisdiction, its decree may be enjoined. Again, the court may have no jurisdiction of the person of the defendant because he lives in another county. In these and similar cases, courts of equity have granted relief. The judgment must be void, however, and not erroneous only, for in such a case there is an adequate remedy at law. Even where the judgment is absolutely void there may be and often is an adequate remedy by appeal or motion. In such cases, relief will be refused. Section 667. Meritorious defense must be shown. It is not the province of equity to correct mere technical wrongs. A party seeking its aid must show some substantial injury. It frequently happens that a judgment is obtained by fraud, accident, or surprise, although the same result would be reached if an adversary trial had been had. In such a case the defendant at law is equitably bound to pay the amount of the judgment, and equity will not interfere to relieve him. The fraud, accident, or surprise is, in such a case, a mere technical wrong. Hence it is laid down that equity will not relieve from judgments in general unless a meritorious defense is shown, so that on a re-examination and retrial of the case the result would be different. This rule is universal as to judgments obtained merely by fraud, accident, or surprise. In cases where the ground of attack on the judgment is want of jurisdiction, as where there is no service of summons, there is a conflict of authority, but the prevailing view is that even there a good defense on the merits must be shown. The cases contra rest upon the theory that everyone is entitled to a day in court. The arguments in their favor are certainly most persuasive. The Constitution of the United States and the constitutions of the various states provide that no person shall be deprived of property without due process of law. When a party is not served with process, he is not in a position to defend his rights if he have any. It is a dangerous doctrine that a void judgment can be sustained. It is a boon to the unscrupulous. A plaintiff may obtain a judgment at will, and unless his opponent can convince the court that his defense is meritorious, relief will be refused. Section 668. Jurisdiction to grant new trials at law. Underscore the jurisdiction of the English Chancery to enjoin judgments at law, not by reason of any equitable right involved in the controversy itself, but on account of wrongful acts or omissions accompanying the trial at law, originated at a time when the law courts had little or no power to grant new trials for such causes. To prevent a failure of justice, a distinct head of equitable jurisdiction was admitted, that of virtually granting new trials, of entertaining suits for a new trial, when a judgment at law had been thus obtained by fraud, mistake, or accident, and the injunction against further proceedings on the judgment was a mere incident of the broader relief which set aside the judgment and granted a rehearing of the controversy in the Court of Chancery. The original occasion for this special jurisdiction has disappeared. In England, and in most if not all of the American states, either through statutes or through judicial action, the courts of law have acquired, and constantly exercise, full powers to grant new trials, whenever from the wrongful acts or omissions of the successful party, or from accident or mistake of the other party, or from error or misconduct by the judge or the jury, there has been a failure of justice. In other words, the powers of the law courts to set aside verdicts or judgments are so ample as to meet all the requirements of equity and justice, and the special equitable jurisdiction with respect to this matter has become obsolete in the very large majority of the states, if not in all of them. The result is, in my opinion, that practically the only jurisdiction now exercised by courts of equity to enjoin judgments at law, where no equitable right or interest is involved in the controversy, on account of wrongful acts or omissions connected with the trial, is a part of and incidental to the broad jurisdiction which equity possesses to set aside and cancel judgments, deeds, contracts, and the like which have been obtained through fraud, undue influence, or mistake. A court of equity, in general, no longer assumes control over a legal judgment for the purpose of a new trial or any similar relief. It will, in a proper case of fraud or mistake, set aside such judgment, and wherever it will grant this final remedy, it will, as a preliminary and incidental relief, restrain by injunction all proceedings upon the judgment. Section 669. Effect of statutory remedies. In many states the reformed procedure has greatly encroached upon the jurisdiction of equity, and a remedy by motion for judgments obtained by fraud or without jurisdiction has been provided. As a result of these innovations upon the ancient procedure, it has seldom been found necessary in the Code states for a suitor to enjoin the enforcement of a judgment at law by means of an interdependent action for equitable relief. At no time would a court of equity interfere if a complete remedy could be obtained at law, and this well-established rule has been frequently applied to cases where the relief sought in equity by an independent action was available to the suitor by motion made under the statute. It is an elementary principle of equity that chancery courts do not lose jurisdiction already acquired merely because courts of law obtain like powers. It would seem that such a principle should apply in cases of this sort, but the courts have seemingly made an exception. The equity courts are not generally completely ousted of their jurisdiction by the legal remedy. Often the remedy by motion proves inadequate, owing either to lapse of time or some other circumstance which renders it impossible to take advantage of it. In such cases equity will relieve. When the remedy by motion or otherwise is provided, a party must either take advantage of it or show some good reason why he has not. If the remedy at law is still open, it must be pursued. It would seem that a remedy by motion is never so adequate a remedy as a bill in chancery. It is informal and generally rests upon affidavits. This certainly, as a matter of fact, is not so satisfactory as an equity suit where the matter can be thoroughly investigated. Where a motion for a new trial has been made at law and has been denied, equity will not, on the same facts, interfere. Section 670. Injunctions against proceedings in foreign jurisdictions. as a court of equity acts in personam, it has the power to and will restrain its own citizens from prosecuting suits in the courts of other states and foreign jurisdictions, whenever the facts of the case make such restraint necessary to enable the court to do justice, and prevent one citizen from obtaining an inequitable advantage over other citizens. Accordingly, proceedings in another state may be enjoined when the claim is entirely invalid and it would work an injustice to compel the defendant at law to resort to the courts of the foreign jurisdiction. It would seem that the true basis of the jurisdiction in such a case is that the foreign court cannot do as complete justice as the domestic court. Thus, in divorce suits, where the plaintiff has obtained a mere colorable residence in another state for the purposes of the action, the defendant may obtain an injunction in the state of residence, the hardship of making a long journey to present her defense appealing to the court. Moreover, in many actions the law of the domicile is controlling. The necessity and difficulty of proving such law in a distant state sometimes inclines a court to settle the case itself. Where, however, the foreign court can do as complete justice to the parties as the domestic court, no injunction will issue. Courts will not allow citizens of their own state to evade domestic laws by resorting to foreign tribunals, as, by suing in a jurisdiction where the exemption laws are more liberal, or by attempting to reach foreign assets after recognizing a general assignment for the benefit of creditors. And where a domestic court has once taken jurisdiction, it may enjoin the parties from commencing proceedings elsewhere, the injunction being granted to protect the jurisdiction and to prevent a multiplicity of suits. The enforcement of a foreign judgment obtained by fraud will sometimes be enjoined. It must be borne in mind in all of the cases that the equity court acts only on the person, and not on the foreign tribunal. Hence, in order that its decree may have any effect, personal service of process must be made upon the defendant. Section 671, Injunctions against Executions. In our discussion of equitable relief against judgments we have necessarily touched upon relief against executions. Where there is reason for relief against the former, there is, of course, ground for relief against the latter. In many cases, however, a judgment may be perfectly valid and yet there may be some vice in the execution itself or in the levy which will warrant the interference of equity. The rule in such cases is that equity will interfere when there is no adequate remedy at law. The main question to be determined, therefore, after the vice itself is admitted, is whether there is a complete and adequate remedy at law. In cases involving personal property there is ordinarily a complete and adequate remedy at law, and therefore relief is as a rule refused. When personal property is illegally taken, damages are supposed to be sufficient to fully compensate for all the injury done. Accordingly, actions of trespass, trivororiplavin afford ample relief. In some cases, however, the property is of such a peculiar nature and has such a peculiar value to the owner, that damages are not adequate. Such, for instance, are cases of family relics and heirlooms, where the judgment defendant is the complainant. The ground of resisting the levy is frequently that the property is exempt from execution. Even in such cases, equity will not interfere unless some special reason is shown for its interference. In cases where the complainant is a third party claiming the property, the courts are more liberal, but even the relief will be refused when damages are deemed adequate. However, when it is inequitable to allow an execution to proceed, relief will be granted in equity if for any reason except lackers on the part of the complainant, relief cannot be had at law. Section 672. Same. Real property. In case of real property the relief is more freely granted. The judgment debtor will be given relief whenever the execution should not be enforced against certain portions of his property and he has no adequate remedy at law. A sale of property exempt from execution, or a sale under any invalid execution, passes no title to a purchaser, yet it casts a cloud upon the title which renders the land unsaleable. It is upon this ground that the courts generally rest their jurisdiction. What constitutes a cloud on title is a mooted question in the various jurisdictions. If, however, the sale is fair on its face and evidence must be introduced to show the invalidity, it is almost universally held that there is such a cloud as equity will prevent or remove. The question frequently arises where a debtor is entitled to a homestead exemption. and the courts uniformly hold that where a sale of a homestead will create a cloud on title, relief will be granted. And the suit may be brought by the holder of the equity of redemption when the homestead has been mortgaged. Where realty is improperly sold in bulk when it is easily capable of subdivision, the owner may obtain an injunction, and especially where the result of sale in such a manner has been to sacrifice the property. If a judgment has been satisfied, or an assignee of the judgment has contracted to save the debtor harmless, or if the judgment is neither a lien upon the property nor a personal charge upon the owner, relief will be granted to prevent a cloud on the title. An injunction has issued to restrain the sale of public school property on execution, although absolutely no title would pass by a sale. A holder of mechanic's lien who purchased the land has been allowed an injunction against a judgment creditor who levied on the land without reference to the lien. Relief will not be granted, however, when the validity of the title is in dispute, nor will an injunction issue to restrain a sale under foreclosure merely because the property will bring a better price if sold under partition. The fact that the plaintiff in an action against an insolvent corporation intends to levy execution upon property which the corporation had undertaken to convey to other parties before the insolvency, does not show any right in the defendant corporation to restrain such levy. Section 673. Same property of third persons. It frequently happens that property of a third person is levied upon as belonging to the judgment debtor. In such cases the ordinary rules apply. An injunction will not lie to prevent the seizure or sale of ordinary personal property, for the owner has an adequate remedy at law. When it is of peculiar value, however, relief may be granted because damages cannot be accurately ascertained and will not compensate. If multiplicity of suits will result, or any other distinct ground for equitable interference is shown, relief may be granted. Sometimes the seizure of property may result in financial ruin to the owner, and involve the destruction of his business. Such, for instance, may be the case when the entire stock in trade of a party is seized. The same result is reached when part of a telegraph line is levied upon. In such cases the remedy at law is clearly inadequate and equitable relief will be granted. When real property of a third person is illegally levied upon, relief is quite freely granted. The ground stated for interference in most of the cases is the prevention of a cloud on title. Generally a sale of such property is sufficient to constitute such a cloud. In some states, however, it is held that where there is a complete record title in the complainant, a sale under execution against a third party casts no cloud upon the title. Accordingly in such states more must appear. Where such a judgment and execution have the effect of a writ of possession, there is a sufficient cloud to warrant interference. In accordance with the principles as laid down above, a wife has been allowed an injunction to prevent the sale of her separate property, or of community property, on executions against the husband alone. The holder of an equitable interest, such as a Statutory trust or one who has a contract of purchase, may enjoin sale under execution against the holder of the mere naked legal title. One who has sold land with governance of warranty has been allowed to enjoin a sale under execution when the judgment has been satisfied. A mortgagee has been allowed to enjoin a sale when his mortgage has wrongfully been marked satisfied, or when a sale would tend to disperse the property. In some jurisdictions a holder of an equitable lien under a deed of trust has been allowed an injunction to prevent an absolute sale in disregard of such deed, but elsewhere it is held that a mortgagee has a mere lien and no title to be clouded, and therefore relief has been refused. It has been held that an owner of a reversion in land cannot enjoin a sale under execution against a life tenant, because a sale passes only the interest of the life tenant. In all these cases the decisions must depend upon the views the courts hold on the doctrine of cloud on title. In at least one jurisdiction it has been held that an injunction will not issue to prevent a levy on the property of a third person until the officer has been given notice so that he can abandon the levy. If a levy will result in the multiplicity of suits, an injunction may issue. Section 674. Same. Not for mere irregularities. An execution sale will not be enjoined nor set aside for mere irregularity in the process. As stated by a court of high authority, the rule is very general that a court of equity will not interfere to vacate a sale under legal process on account of irregularity in the issue of process, or in its execution, but, as is properly said, the application ought to be made to the court issuing the writ, and if made elsewhere ought not to be entertained. There must be accident, surprise, mistake, or fraud, or some fact or circumstance affecting the sale itself, and not resting on the irregularity of the process, or irregularity in its execution, before a court of equity will take jurisdiction to vacate it. As full relief can ordinarily be obtained by motion, there is no reason for equitable interference. Accordingly, an injunction has been refused where relief was sought on the ground that part of the property levied upon did not belong to the complainant, or that an execution was issued to another county when no execution had been taken out, or in the county where the judgment was rendered, where the judgment creditor will be entitled to another execution if one issued prematurely is enjoined. When the individual personal property of a surviving partner, who is administrator of the partnership estate, is seized under execution on a judgment against the firm, a sale thereunder will not be restrained by injunction because the execution was issued in the name of a dead man, or the judgment, prior to the issuance of the execution, had been presented as a claim against the estate, and neither allowed nor disallowed, nor because the levy was made on individual personal property. An injunction will not issue because of mere defect in the notice of sale, nor because of a misdescription of the premises, when the land may be readily identified, but where the description is so defective that the property will not bring a good price, equity will interfere. The mere fact that property will not bring a good price if sold at the time is no ground, however, for equitable relief. Miscellaneous cases are appended in the note.